Now, I am going to dictate a legal passage at the rate of 160 words per minute based on latest Supreme Court judgment. Let's start. The specific allegation in the complaint is that on 8th January 2017, the appellant numbers 2 to 6 were present on the suit property and they broke the fencing, which caused a loss of rupees 50,000 to the first respondent. It is alleged that when the first respondent objected to the appellant's verbally abused the first respondent and he was pushed several times, even a death threat was administered by the appellants to the first respondent. The appellants also threatened the first respondent to send him to jail. The Ladder Judicial Magistrate Gwalior, before whom the complaint was filed, recorded the statement of the first respondent under section 200 of CRPC. It appears that the Ladder Magistrate took recourse to the inquiry under section 202 of CRPC and recorded statements on oath of two witnesses of the first respondent, Hori Singh and Lokhun Singh Pera. By order dated 23rd June 2018, the Ladder Magistrate dismissed the complaint in exercise of powers under section 203 of the CRPC. The Ladder Magistrate held that the mandatory requirement of obtaining a sanction to prosecute the appellants in accordance with section 197 of CRPC was not obtained in a revision papered by the first respondent against the order of dismissal of the complaint. The Ladder Additional Sessions Judge interfered. The Ladder Additional Sessions Judge held that there was no inquiry made by the Ladder Magistrate on the issue of whether the appellants committed the acts constituted alleged offences in the discharge of official duties, the non-performance of which would have made the accused persons answerable for the dereliction of the official duties. Therefore, an order of remand was passed to enable the Ladder Magistrate to record a finding on the necessity of obtaining sanction for all the offences alleged. After the order of remand, by order dated 11th October 2018, the Ladder Magistrate passed on an order directing the cognizance to be taken under section 294, 2323, 427, 447 and 506 II of IPC. The Ladder Magistrate did not record any finding on the issue of sanction. This order of the Ladder Magistrate was subjected to a challenge before the High Court by invoking provisions of section 482 of CRPC. By the judgment, the High Court dismissed the petition. The Ladder Senior Counsel appearing for the appellants urged that even taking the amendments made in the complaint as correct, the acts attributed to the appellants were done by them in the performance of the statutory duties as officers of the SAPA, and the Ladder Magistrate has completely overlooked this aspect. In fact, he has not decided on the issue of the requirement of sanction at all. He submitted that even otherwise, in view of the earlier dismissal of the contempt petition, the order of summoning ought not to have been issued by the Ladder Magistrate. The Ladder Counsel appearing for the first respondent submitted that with due application of mind, the Ladder Magistrate issued process. The Ladder Magistrate had recorded the statements of three witnesses, including the first respondent, that was done based on materials on record. He submitted that committing acts of trespass cannot be a part of the appellant's official duties. Thank you.